Next matter to come to court this morning is the state of Martha Henderson versus Jean Henderson, DDS. Both parties will have 15 minutes in which to present the case. If they're the appellant, you wish to retain some of that time for rebuttal. Let me know when you come up here to the podium. I'm keeping track of the clock and keep your price and passage. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read the briefs and we're ready to proceed.
Thank you, Your Honor. Good morning. My name is Eric Zagrins. I represent appellants the state of Martha L. Henderson and two of his three beneficiaries, Thomas L. Henderson and James P. Henderson. I would like to reserve 4 minutes of my time for rebuttal.
Thank you.
May it please the court. If Thomas Henderson had testified at trial in this case, consistent with the averments in his two affidavits from 2012 and 2017, it would have been received in evidence. It would have been deemed competent evidence for that witness to have provided. If Deborah Henderson had been called to trial and testified consistent with her 2012 affidavit, it would similarly have been deemed received in evidence and competent testimony by a witness who was presenting firsthand knowledge and information. If the opposing testimony by Mary Ann Remick in her 2010 affidavit had been actually received in evidence at trial, it similarly would have been received, and the evidence, conflicting evidence from both sides, would surely have gone to the jury in the case for the jury to determine what it considered to be the true facts of the matter. It would have considered the credibility of the witnesses from their demeanor, etc., and would have also looked at the documentary evidence that was submitted from the credit union's documents and records, and would have taken those into account. What actually happened in this case on summary judgment, however, is that the trial court erroneously usurped the authority and power of the jury to make those determinations of fact, to assess the credibility of the conflicting evidence and the witnesses presenting them, and entered summary judgment in the face of that conflicting evidence. Why and on what basis did the trial court do that? Well, the trial court discounted Mr. Henderson's 2017 affidavit based on the trial court's belief that it was merely self-serving because Mr. Henderson had something to gain. That is to say, he would have shared 1/3 if that $185,000 wire transfer had been clawed back into the estate, and therefore discounted his affidavit. The trial court also disregarded, as far as the judgment entry in the case, entirely the 2012 affidavits of both Mr. Henderson and his ex-wife, Deborah Henderson. The trial court also didn't talk about at all the documentary evidence that was submitted by plaintiffs in the case, including the wire transfer form that had anomalies in it that I'll talk about in a second, and the documentation both from the affidavits and from the records of the credit union that these funds weren't even Mr. Henderson's funds to wire in the first place, that they came from the account 6120-008, a money market account that was owned by Mrs. Henderson, and there's certainly, that's to say Martha Henderson, and there's certainly nothing in the record to indicate that the father, Pete Henderson, had any power or control or authority over her fund.
Do the credit union documents show that this was Mrs. Henderson's account as well, or is that just his opinion?
Your Honor, it was ambiguous from those records. We have Mary Ann Remick's affidavit, which lists various of the sub-accounts of 6120, indicating that, for example, the 009 account was a joint checking account. So there's some reference to an account being joint, other references to sub-accounts being Mrs. Henderson's, Martha Henderson's account alone. Nowhere does it indicate that the 008 account was joint with Martha's husband, Pete.
And that's where the 185 came from.
And that's where the 185 came from. But, Your Honor, there were a series of counter transactions, meaning that someone actually came to the bank in person to conduct the transactions earlier in September of 2007 on at least 3 different occasions to transfer about $200,000 from other sub-accounts belonging to Martha Henderson into that money market account as a prelude to the wire transfer out of that account for the benefit of Jean Henderson. And there's no indication of how those were made and who made them, other than the fact that they came out of Martha Henderson's sub-accounts and were put into that 008 account. And if you look at the testimony of 2 people with firsthand knowledge of what Pete Henderson's physical and mental condition was in September of 2007, and Martha Henderson's mental condition in September of 2007, there's simply no way to conclude that the events could have happened if you credit that evidence. If that evidence is given credit and inferences from that evidence construed in favor of the plaintiff, no way to conclude that Mr. Henderson strolled by himself into the credit union on September the 21st of that year and conducted the transaction in the way that Mary Ann Remick's affidavit says it was conducted. He was physically incapable of doing so. Tom Henderson's 2 affidavits, one in 2012, one in 2017, aver that he was in such bad shape from congestive heart failure. His legs were so swollen and painful that he spent his days, most of his days, in a reclining chair in the living room. They had moved a bed into that living room as well for him to sleep in. And that for him to walk as much as 10 or 20 feet was incredibly painful for him to do, that he had to have assistance to do that, and that walking a longer distance than 10 or 20 feet, such as walking into the lobby of the credit union and sitting down with Mary Ann Remick and conducting a wire transfer, would have been physically impossible for him to do. Now, there's no contradictory evidence in the record whatsoever to those points, other than Mary Ann Remick saying, Mr. Henderson walked into my lobby and sat down in my office and conducted the wire transfer transaction.
But were his opinions or observations buttressed by invoices from hospice or assisted living services?
No, Your Honor, there was no hospice or assisted living services. There was no buttressing evidence in the way that Your Honor is asking about.
Do you think that was necessary?
No, Your Honor, I don't think it was necessary. It might have been nice, might have been prudent to have, certainly, would have enhanced the record for the fact finder to be able to draw the conclusion in favor of the plaintiff on that point, would have helped, but not necessary in order for the fact finder to have competent, credible evidence from which to decide which of the 2 conflicting views. The point is, the trial court is not allowed to usurp that when presented with this kind of evidence. And moreover, the trial court itself said, you know, this whole transaction doesn't pass the smell test. The whole transaction is puzzling because the evidence was that the wills specified that the 3 sons were going to share in the estate of both of them equally. Regardless of which one was the second to die, the result was going to be essentially the same. When Pete Henderson died, his entire estate went to his surviving spouse, Martha, because he was the first to die. When she died almost 3 years later, then her will controlled, and the 3 sons were supposed to share equally. But yet, supposedly, 3 months, less than 3 months, before Mr. Henderson dies, he suddenly transfers almost $200,000 out of the money of his wife and gives it to one son to the derogation of the other 2. The trial court said that didn't make any sense. And the court said it's puzzling, it's troubling, doesn't pass the smell test. And yet the court found, in the trial court's words, there's no substantial challenge to Mary Ann Remick's evidence. Well, certainly there was substantial challenge if you don't discount Tom Henderson's 2017 affidavit, and if you don't ignore the 2 2012 affidavits from Tom Henderson and his ex-wife, Debbie. So there was significant indication, both from affidavit evidence and from documentary evidence, that supports a completely contrary version of the facts from what Mary Ann Remick, who, by the way, the time these issues took place, these events took place, was an officer of the credit union, which was an original defendant in the case. They settled out in the year 2015 while the case has been pending. The court said she didn't have a dog in the fight, and therefore she's more credible than Mr. Henderson, who stood to benefit if the transaction was unwound. Well, she did have a dog in the fight. No, she wasn't personally named personally as a defendant, but it was her actions that were being challenged by the plaintiff's position in the case, in saying that this transaction couldn't have happened the way that she said and should be unwound and the money clawed back into the estate. So she did have a dog in the fight, and the trial court was simply wrong to characterize it that way.
She wasn't a party, nor was she working for the credit union at the time of the affidavit, was she?
Not at the time of the affidavit, but she was working for the credit union at the time these events took place. And that's the key, because it was her actions at the time the events took place that were being directly criticized. She would have had a lot to account for to her former employer if she had done the transaction wrongly. Finally, we have the wire transfer. I'll take one more minute, Your Honor. Thank you for letting me know. We have the wire transfer document itself that is very puzzling, because first of all, it says clearly, if you look at Exhibit 14 in the record, it says it's dated June 21st. There's a 6/21/2007. Someone wrote over the 6 after it was written with a 9 to make it 9/21, September 21 of that year. Then it says on the transfer form, due, meaning we say, this is our inference from that word, due, D-O, executed on 9/21/2007. Why would there have to be a note to say to execute the transfer on that date if Mr. Henderson had actually appeared in person on that date, supposedly, to initiate the wire? That would be unnecessary. It would be silly, absurd. Then on Exhibit 15 is the same form, but with a Post-it note superimposed on it that we got from the credit union's records. And the Post-it note says, if there's any trouble with the wire, call Gene Henderson, the son for whose benefit the money was wired out, with Gene's cell phone number, Gene's office number, and contact information. If this was a wire that Mr. Henderson, the father, supposedly did in person in the way that Mary Ann Remick says, and the way that Tom Henderson and his former wife say was impossible for him to do, why would there be a note saying, if you got a problem, call the son rather than Mr. Henderson himself? So there's lots of evidence from which this matter, this issue, which is the substantial issue in this litigation, this $200,000 represents the lion's share of the financial stake in what is at issue in this litigation between the estate and the one son. There's significant evidence that this matter should have been left for the jury to determine, and that's what we're asking the court to do, to send it back for a jury trial. Thank you.
Good morning, Your Honors. Again, I'm Ken Werner. I represent Gene Henderson in this case. Let me know when you're ready. Go ahead. The appellant characterizes the affidavits of Tom Henderson and Deborah Henderson as competent evidence to rebut the partial summary judgment that was granted in the court. He also talks about documentary evidence that it was submitted along with it. One of the evidence that was submitted was Exhibit 11, which is a signature card that has only Martha Henderson's signature on it. However, that card was signed on December 28th, and Pete died on 8 days earlier. He died December 11th. And Mary Ann Remick clearly stated in her affidavit that Martha Henderson had changed all the accounts that were held jointly into her own name shortly after Pete's death. So Pete was already dead when that signature card that they're purporting to was signed. In addition, when you look at the wire transfer card, you'll see that on that Mary Remick signed it as having verified Pete's signature on that day. There is a 9 that that looks like it was someone was written over it, which I never even noticed before. But Mary Remick testified that, and she is the only eyewitness. She's the only eyewitness to testify. Tom and Deborah weren't there, but Mary Ann Remick testified, or sworn under oath, that Pete walked into that credit union and made that transfer. Mary Ann Remick also said that a week before the transfer, that Pete had called the credit union to make arrangements for setting up that wire transfer. Mary Ann Remick testified, or swore under oath, that when Pete came into the credit union, that she read the entire documents word for word to him before he signed it. She said that when the money was taken out of the account, she told Pete and gave him a receipt after she'd read the wire transfer to him and he signed it. She said that later on in the day, she called Pete to tell him the wire transfer had been completed. And she also said, Mary Ann Remick also stated that there was notice on the accounts, the statement accounts that they sent to the Hendersons, that money had been transferred. That shows that Pete considered this, that he considered it for at least a week before he actually initiated any action. Mary Ann Remick really had no reason to lie about this, and that document, that wire transfer document, proves that she's telling the truth. As far as Gene's number being on the bottom, Tom said in his affidavit, Tom Henderson, that Gene was responsible for taking care of most of his family's financial affairs, for most of Pete and Martha's family financial affairs. So that would be one reason why that might have been put there. Maybe Pete Henderson didn't like talking on the phone. Maybe he didn't want to deal with this on the phone, and that's the reason he told Gene. Is all you have is wild speculation that this might have been Gene setting up the account. And the only proof that the appellant has is that Gene's phone numbers were on the ballot to call for the wire transfer. But you have Mary Remick's concrete testimony under oath in her affidavit that this is the way this happened, and that wire transfer proves that this is the way it happened, and the signature card only proves that Martha Henderson transferred account that was held by her and Gene into an individual account. In addition, in Mary Ann Remick's affidavit on page 6, she clearly states that account number 6120008 was a money market account that was owned by both Pete and Martha at the time. And so there is evidence that it was owned by them jointly. There is no evidence that it wasn't, other than the speculation and claims by the appellants. The court didn't discount Tom's affidavit because he was party to the case. The court discounted Tom's affidavit because they had nothing to back up that documentation. There were no doctor's reports, there was nothing from any independent witnesses, and Tom's a lawyer, so he should have known how to do this, and he's represented by competent counsel. And they would have known how to get those doctor's records and so forth if they actually existed. The fact is they want the court to rely just on their assertion, which is exactly the type of affidavit that the Supreme Court of Ohio and other courts have said is not sufficient to overcome a motion for summary judgment. Bald assertions that just contradict what the moving party says. If that were enough to overcome summary judgment would never be granted. If all you had to do was say that that is wrong, that they're lying, and these people have accused Mary Ann Remick of lying about the way that Pete came in and transferred that money. The appellant cites Drescher versus Burt as one of their cases, but as overcoming, as preventing summary judgment. But the Drescher court relied on a transcript of a deposition, a letter from one of the dead person's employers, and a letter from an insurance company. The Drescher report, court did not rely on any unsubstantiated claims from anybody. They relied on a deposition where a person was under cross-examination and other types of independent statements, not statements from parties. The Bay versus Brentlinger Enterprises, which is also a case that the appellant cited, says that unsupported and self-serving assertions in an affidavit that amount to nothing more than the bare contradictions of the evidence offered by the moving party can be insufficient in defending against a motion for summary judgment. And that's White versus Sears. But it was Bay versus Brentlinger, quoting White versus Sears. But that's all you have in this case is Mary Ann Remick coming forward and stating, this is how this happened. I remember how it happened. I read every word of the wire transfer to him. I was in constant contact with him. And surely Mary Ann Remick, if Pete had been incompetent, would have not let this transfer gone through.
You agree with opposing counsel's initial statement that Tom and Deborah would have been able to testify at a trial concerning those matters that are set forth in their affidavit? Would have been admissible testimony.
Yeah, I think it would have been admissible testimony, but it would have been their opinion of what they saw on that day. In addition, in those affidavits, they don't say that Pete couldn't walk. Is what they say is Pete had trouble walking. They talk about swelling and pooling and a congestive heart disease, but they didn't offer any doctor statements or any medical report or any supporting evidence. No one until 2017 said in their statements that Pete could not walk. In addition, in none of those statements was there anything said about Pete's mental condition. It wasn't even mentioned. There's no mention that maybe somebody maybe Gene had control over Pete, or maybe that Pete was suffering from dementia. That wasn't mentioned in any of those affidavits. And as far as Tom saying that his father would have never done this, what Tom's rationale was that Tom and James, the other brother, were having financial difficulties, and his father would have never given this money to Gene the way he did. That is pure wild speculation. Gene was the son who stayed home and lived across the street and took care of his parents. Gene was the one who drove them around and was at their house making sure they were okay every day, while the other two brothers, Tom and James, lived elsewhere. I believe at that time that James was living in Cincinnati and Tom may have been living in Columbus. They weren't available. Maybe that's why Pete gave Gene that money. I saw Alan Dershowitz on TV on a Sunday program one time, and he was talking about motive, because the court said, what was the motive for Pete to give Gene this money? And what Alan Dershowitz said, the reason motive is never an element of a crime or part of a legal suit is because it's very complex and very hard to determine what the motive is. And so it's hard to go to that motive. And in addition, when the court says that, when the trial court said that this doesn't pass the smell test, that something's funny, to me that indicated that the trial court applied the proper analysis to the case and viewed the like most favorably to the appellant. It showed that the court considered the evidence, and after their consideration, decided that there was no compelling evidence to contradict the affidavit of Mary Ann Remick.
Is there a difference between considering evidence and weighing evidence?
I don't know if there is a difference, Judge, in my mind.
Does there have to be under the summary judgment rule?
Does it have to be what?
Difference between considering and weighing?
True, the judge weighed the evidence. In this case, he considered and weighed the evidence, and in this case, and decided that there was no compelling evidence to contradict Mary Ann Remick's statement. The only eyewitness, the only person who was actually there was Mary Ann Remick. Don't say that she possibly could be disingenuous because she was part of this transaction and she might have done something wrong. That's nothing more than an accusation with no substance to back it up. This is just saying to the court, don't grant summary judgment, and we're going to give you reasons with nothing to back it up, no evidence, no corroborating witness statements, no doctor's reports, and you're supposed to believe us. Now, the appellants say that each of the brothers was to share in the estate. This money wasn't in an estate. It was an inter vivos gift from Gene to Pete before he died, which means it was not in anybody's estate. So, even if Pete did mean for everybody to share in the estate, he didn't tell them what that estate was going to be.
The court really didn't analyze it as an inter vivos gift, did it?
Yes, they did.
Did he?
Well, yeah, they did. The court actually gave us attorneys kind of direction in one of their rulings. They wanted us to talk about inter vivos gift. And we, as the, when we filed our motion for partial summary judgment, we definitely talked about an inter vivos gift, yes. That was the main crux of this, that this is an inter vivos gift. It wasn't part of any estate. And that it occurred exactly as Mary Ann Remick said. There's no reason not to believe that, other than people saying it couldn't have happened that way. That's not enough to overcome summary judgment. You know, Gene was a guy. He was the guy who took care of his parents. He was the one that stayed across the street. Mary Ann Remick said that when the power of attorneys that were talked about in the appellant's brief were delivered to the credit union, that 40 days after that, Gene died. She said Gene never transferred any money or made any transactions according to that power of attorney. So one of the things that appellants are saying is, well, Gene must have used his power of attorney to transfer these funds. That's just not true. And the only way you can do that is to call him, just say, oh, Mary Ann Remick's lying. But then you need to back it up, don't you? If Mary Ann Remick's lying about Pete walking into the credit union like he did, shouldn't have the appellants provided doctor's reports? I mean, if he's suffering from congestive heart disease, they would have certainly been a physician that they could have got these records from, which would have bolstered their claim. Wouldn't have even been it true in that case, because Mary Ann Remick was the only eyewitness. So the only way that you could rule in favor of the appellants is if you decide Mary Ann Remick's lying somehow. And Gene feels betrayed because he stayed home, took care of his brothers, and now he's in a position where they're saying, you did something wrong, give us the money back. It's hurt him. And I know that you as judges may feel the same as the trial court, that you may feel, well, this doesn't pass the smell test, something doesn't seem right about this, or what was Pete's motives for doing this. But the fact is like I talked about before, motive is never a part of any type of lawsuit or any type of crime because it's just too complex and too difficult. We don't know what Pete's motives were. Maybe his motive was that this was the kid that took care of him and he wanted to help him out. So it's difficult, and the fact that the court considered that shows that they weighed and just considered this. No matter what happens in this court, the Henderson is going to be changed forever because these type of fights are the type of fights that break up families. However, Pete was a lawyer. Pete, the father, was a lawyer as well. He made this transaction. He knew what he was doing. He did it ahead of time. Mary Ann Remick swore under oath of how this happened, that Pete came in by himself, no power of attorney. He set up the transaction a week ahead of time, and that Mary Ann Remick was in constant communication with Pete during this to make sure that he knew what was happening. The only thing you have is Tom and Jean and Deborah, Tom and Deborah wildly speculating that something's amiss, that somehow Mary Ann Remick is lying, that their father really didn't mean to give this money to Jean, when in fact, it's all you've got is proof that he did mean to give it to Jean.
That's where you're out of time.
How about that? Thank you, Judge.
Thank you. Attorney Zingerman, just over a minute and a half.
Thank you, Your Honor. 4 quick points. Number 1, the statement by Appellee about the law on self-serving affidavits is just wrong. Yes, the law says you can't have self-serving affidavits. Self-serving affidavits means a bare or bald contradiction of the affidavit supporting the motion for summary judgment. That's not what we have here. The Bay versus Brentlinger decision by the 10th District, in 2016 confirmed that the affidavits in this case are not to be disregarded as self-serving. Tom's 2017 affidavit was 6 pages and 12 detailed paragraphs. His earlier affidavit, 6 pages and 17 detailed paragraphs. Deborah's affidavit in 2012, 5 pages and 8 paragraphs. They didn't just say, everything they said over here in this other affidavit is wrong or didn't happen. They went through detailed dates, times, events, incidents. Look at those affidavits for yourselves and see it's not simply a contradiction. It's a counter affidavit that sets forth substantive evidence, and that's not what is meant by a self-serving affidavit. Point number 2, the Remick affidavit does not say that the 6120-008 account is a joint account. It says the 6120-009 account is a joint checking account. It does not identify the 008 sub-account as a joint account. Third, we are not relying on the post-death signature card. That's not part of our evidentiary submission. And finally, I remind the court that the wire transfer form was filled out by Mary Ann Remick. It's her handwriting that appears on the card at all points other than Pete Henderson's purported signature line. Thank you very much. Ask that the court reverse the entry of summary judgment.
Thank you both for presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and that of the Supreme Court.
Thank you, Your Honor.
Thank you.